Good afternoon. This is the 42 Bedford Row Housing Group workshop on rent repayment orders. I am Howard Lederman, and I will be presenting this workshop alongside my colleague, Natalie Foster, who will be joining us a bit later on. I intend to speak for about 10 minutes. There is a video PowerPoint that accompanies this presentation that contains notes of what's being said. You needn't try and keep all the notes whilst we're talking. This will be a brief overview of rent repayment orders as it affects local authorities. The video will be found later on our YouTube website. You should also see a copy of the PowerPoint on our 42 Bedford Row website. There will be an opportunity for questions later on after Natalie has spoken, and we'll do our best to answer as much as we can. It would be really helpful to us if you could send your questions in on the question and answer facility that you should find in Zoom. We'll do our best to answer them. If there's anything that we can't answer immediately, we will look at them, and if you provide us with a contact address afterwards, we'll aim to come back to you. 42 Bedford Row Barristers regularly do all kinds of housing work. We have experience of rent repayment orders. We're very keen to work closely with our local authority colleagues to ensure that rent repayment orders work as smoothly as possible. The first question to look at then is, well, what is a rent repayment order? So for local authorities, what this means is an order obtained from the first tier tribunal, which is part of the property chamber, requiring a landlord to repay back those parts of universal credit that have been paid for rent, in respect of rent, for a property within the local authority's area. This can only be made where the landlord in question has been found guilty of a specified housing offence in relation to that particular property. We will discuss which offences are relevant later on in this presentation. If there has not been a conviction in a magistrate's court separately, then the local authority will need to establish that the landlord in question has been guilty of one of the specified housing offences in order to obtain a rent repayment order. It will need to do so to the criminal standard of proof, that's to say, beyond reasonable doubt. Rent repayment orders were introduced as long ago now as 2004, 2005, but recently in 2017, the rules changed with the introduction of the Housing and Planning Act 2016. The rules have changed significantly, so it is important to keep up to date and look carefully at the modern law. A word of warning, this is a developing area, and the law is changing and being developed from month to month. So the next question is, well, I'm a local authority, or I'm working for a local authority, why should we look at rent repayment orders? And the reason for that is that if there has been a conviction of a landlord for one of these specified housing offences that we'll come back to within its area, then a local authority is required to consider applying for a rent repayment order. That's the first reason. There is a duty to consider applying for one. The second reason is local authorities might want to recover the costs and expenses they've incurred in their private rented sector enforcement duties relating to improvement notices, prohibition orders, and other matters. And thirdly, most local authorities will have a policy relating to rent repayment orders and also prosecutions and possibly civil financial penalties that will require them to consider making rent repayment orders. So the next question is, if there's been a prosecution of a landlord for a relevant specified offence, can the local authority also apply for a rent repayment order in respect of the same offence? Fortunately, there is a clear answer to this, and a local authority can apply for a rent repayment order where there's been a prosecution for the same offence. So the next issue that most local authorities will want to look at is what their policies say about a rent repayment order. So there may be advantages to applying for a financial penalty under Section 249A of the Housing Act 2004 instead of or at the same time as a rent repayment order. Alternatively, the local authority may want to consider a criminal prosecution. In most cases, a civil financial penalty or a rent repayment order will be an easier prospect than attempting to prosecute through the magistrates' courts, particularly in the times of the pandemic. If you're thinking of, as a local authority, of applying for a civil financial penalty and a rent repayment order in order to try and recoup as much as you can, then you can only do that for one of three specified housing offences, and those are failure to comply with an improvement notice, licensing offences for houses in multiple occupation, usually under Section 72 of the Housing Act, either controlling or managing a house in multiple occupation without a licence, when a licence should have been applied for. Or thirdly, licensing offences for what are called Part 3 houses under Section 95 of the Housing Act 2004. So those are the three types of offences where you can apply for a rent repayment order and a civil penalty. And that way, if successful, the local authority may recover a considerable amount of its expenditure in enforcement activities. Time limits. So it's important to bear in mind that there are quite strict time limits for applying for a rent repayment order if you're a local authority. You must apply in respect of any of the specified offences that we'll come on to within 12 months ending on the day that the application is made. So the offence must be committed within that 12-month period. There is also a separate rule that requires a local authority to serve a notice of intended prosecution before applying for a rent repayment order, and that must be within 12 months beginning on the date when the landlord committed the offence. How the notice of intended prosecution rules are going to be interpreted is still to be debated and hasn't been finalised, and you need to watch this space and take separate advice. Things to consider in deciding whether or not to apply for a rent repayment order. As I said before, there's the local authority's policy. There is guidance, statutory guidance published under the Housing Act 2004 and the 2016 Act by the government. There is also the Crown Prosecution Service Code on prosecutions, and a local authority is also required to have regard to and take into account any representation served by a landlord in response to a notice of intended prosecution. And at last, we come to the offences for which a rent repayment order can be made. And we've already talked about three of them. The first one is offences relating to house in multiple occupation, which should be licensed, but for which a license has not been obtained. The second relates to control or management of unlicensed houses, usually Part 3 houses. And that may include flats, usually where there's an element of selective or additional licensing. And as I said before, failure to comply with an improvement notice, and in this case, or a prohibition order. And then there are three additional types of offence for which you can apply for a rent repayment order: eviction or harassment of occupiers under the Protection from Eviction Act. And fifthly, breach of a banning order. Those are incredibly rare at the moment. And then finally, violence to secure entry under the Criminal Law Act. Moving on to what you need to prove if you're applying for a rent repayment order as a local authority. Firstly, and this is something that often causes problems, the local authority has got to prove the commission of the relevant offence beyond reasonable doubt. So to the same standard as if it were a prosecution. Some of the offences will be easier to prove than others. So the offences in relation to control or management of a house in multiple occupation or a Part 3 house, licensed house, those are what are called strict liability offences. There is no need to prove, in most cases, an intention or knowledge. There is a statutory defence that's available to some defendants, a reasonable excuse, but that is of very limited effect. And in most cases, ignorance will not amount to a reasonable excuse as a defence. When we get to the question of quantum, that all that has to be shown, all that has to be proved is more likely than not on the balance of probabilities. So what evidence will a local authority need to be successful in a rent repayment order? Firstly, ideally there will be more than one witness to any events or facts which are alleged. Secondly, many local authorities provide witness statements which are in the form approved by Section 9 of the Criminal Justice Act, with the appropriate warning in by each of the witnesses, and hopefully each of those witness statements will be in a form that would be appropriate to a prosecution and contain the relevant warnings. If there were any admissions or interviews, there should also be written records of those, complying with any relevant code of practice, and particularly relating to houses in multiple occupation where there's been a designation of additional licensing or selective licensing, some legible copies of the area of designation. That sometimes proves to be a problem. Then in relation to quantum, you will obviously need details of the amounts paid. In respect of rent, there's universal credit. And finally, of course, need to check that all the information provided is compliant with the Data Protection Act and GDPR insofar as it's still in effect. Who can you apply for an order against? Which kind of a landlord? Well, until very recently, it was clear that a rent repayment order could be made against any landlord, including a superior landlord. This has recently come under challenge, and that is now due to that challenge in the Repayment case is due to be heard in the Court of Appeal in the near future. Does the tribunal have a discretion to refuse making an order? Well, there is some authority for the proposition that there is a residual discretion, but it's now very clear that that discretion will usually be exercised in favour of making an order where the other conditions have been satisfied. the amount of an order made as a rent repayment order. But I just mentioned one particular point that's relevant to local authorities. So where there has been a conviction or a civil financial penalty made against a landlord, then there is a mandatory amount that must be paid by the landlord, or the rent repayment order must relate to. And that is 12 months ending in the amount of the universal credit paid in respect of rent for the 12 months ending with the date of the offence, or in a 12-month period during which the landlord was committing the offence. That is unless there are exceptional circumstances. So those are the where there's been a conviction or there's been a civil financial penalty. But we will deal with some questions and answers, hopefully through the question and answer facility at the side of this Zoom later on. Thank you very much. I look forward to hearing any questions that we can deal with in this Zoom forum. And I hope this part of the workshop has been helpful so far.
Good afternoon, everybody. Thank you very much for the introduction, Howard. It's right that my name's Natalie Foster. I am also a barrister at 42 Bedford Row, and I am a specialist within the housing team. What I'm going to be doing is just taking possibly another 10 minutes of your time before we embark on answering some of your questions, really just to look at the quantum and how much can be awarded in respect of a rent repayment order. And so what I'll do is I'll just pick up really where Howard has left off, because the first consideration for the tribunal is, has the landlord been convicted or not? And obviously it's not just a conviction, it's also whether they've received a financial penalty in relation or in respect of a specific offence. And yes, Howard has already explained that if the answer is yes, then the first tier tribunal must order the maximum amount of rent up to 12 months. And that is regardless of whether or not the local housing authority has applied for a lesser amount or not. And the tribunal will do that unless it's unreasonable to do so. If the landlord has not been convicted or had a financial penalty, the first tier tribunal will determine the amount to be repaid in accordance with Section 45 of the Housing and Planning Act 2016. I just note here for a moment that there is a separate section under the Act, Section 44, that deals specifically with rent repayment orders made where the tenant is the applicant. I just note that so that you know when you're considering the Act that there are some slight differences in relation to Section 44, but the section you need to be dealing with and looking at is Section 45. And what that says is that the first tier tribunal can make an order for all of the rent paid to the landlord by the local housing authority in respect of universal credit up to a maximum of 12 months rent. And so the difference here in relation to whether the landlord has been convicted or not is that if they're not convicted or have to pay that financial penalty, then this is discretionary. And so what we then need to look at is the tribunal's discretion and how do they exercise that discretion. So the first thing to look at is Section 45(4) of the Act. Within Section 45(4), what it says is the tribunal must, in particular, take into account the conduct of the landlord, the financial circumstances of the landlord, and whether the landlord has at any time been convicted of one of the relevant offences. And these are the offences that Howard has already explained and outlined to you. In the case of Vadamalian last year, the upper tribunal decision appeared to suggest that those were the only factors that could be taken into account when the tribunal was exercising its discretion. However, when you look at the Act, what it says is that those factors must, in particular, be taken into account. And so I stress the words "in particular," which suggests that the tribunal does still have a general discretion. And then in a recent case, a case last year in the upper tribunal of Chan and Bilku, Judge Cook confirmed that the first tier tribunal was not limited to the statutory provisions, and therefore there was no limit to the things that could be considered in relation to the level of the rent repayment order. So then the next thing is to look at the case of Lederman, and in particular the principles that were established there. In that case, the upper tribunal confirmed that any expenditure incurred by the landlord for maintaining the property would not be deducted from the overall award, as these were part of the landlord's obligations under the tenancy agreement. So this includes mortgage payments. The tribunal in that case took the view that mortgage payments were an investment in the property and therefore did not justify the tenants to contribute towards the investment through deductions in respect of the rent repayment order award. It follows from that it's unlikely that tribunals will therefore deduct mortgage payments going forward. However, that doesn't preclude the landlord from submitting evidence in relation to mortgage payments, loan payments, or any other such, because financial circumstances, as I've discussed earlier, can still be considered by the tribunal when looking at section 45(4) in terms of the statutory considerations that the tribunal must have. In that case, the upper tribunal went further, because what they went on to state is that the tribunal can discount payments made by the landlord towards utility bills if the landlord pays for those utility bills out of the rent. The tribunal said that those were services provided by third parties and they were used by the tenants at their own rate and enjoyment. One last thing to consider from the decision in Lederman is that payments towards the financial penalty would not justify further reductions in the rent repayment award. The tribunal there confirmed that it was Parliament's intention that the landlord should be liable to pay both the financial penalty and the rent repayment order in respect of these licensing offences and otherwise. And so there is a clear emphasis on the punitive element of the tribunal's decision making in deciding the rent repayment order award. A relevant consideration for the tribunal is whether or not the tenant was in arrears in respect of that relevant 12-month period. And this was something that was considered in the recent case, a case decided this year in the upper tribunal of Awad and Hooley. This was within the first tier tribunal an application by a tenant against her landlord for a rent repayment order in respect of a failure to license the property. In this instance, the tenant was in arrears during that relevant 12-month period. However, she was making some payments towards the rent. The first tier tribunal held that in that particular set of circumstances, as the arrears were accrued prior to the relevant 12-month period, the tribunal was satisfied that it would essentially be standard accounting practice for any landlord or council, housing association to apply the payments that were made during the relevant period first to the arrears that had accrued prior to the date of payment. So they said that's standard accounting. So therefore, any payments made by the tenant in the relevant 12-month period would be treated as first going to the arrears and then being applied to the rent. So therefore, a calculation in this case was necessary to determine what rent was actually paid and attributable to that relevant 12-month period only. The tenant appealed and it was decided this year in relation to that. The upper tribunal dismissed that appeal and upheld the decision of the first tier tribunal. Another consideration was and is, what if there are multiple offences? And if there are multiple offences, can you get more than one rent repayment order? And this was decided this year in the case of Vicara and James. In this instance, again, it was an application made by the tenant for a rent repayment order, but it was made because the landlord had failed to license the property. It was made in respect of harassment and illegal eviction. And what the tenants did in this instance is they sought a rent repayment order of 12 months rent in respect of each of the 3 offences. The first tier tribunal, they were satisfied that all of those 3 offences had indeed been committed, but they said that they could only award 1 rent repayment order up to the maximum of 12 months. The tenants appealed and the upper tribunal essentially said what we need to do is look at the wording of section 44, and the same would apply for the precise wording of section 45. Because what that does, it precludes an award per offence. The amount the landlord may be required to pay in respect of a period must not exceed the rent paid in respect of that period. And that's different to the offence. So the specificity is in relation to the rent paid during that period. So in that particular case, whilst the period was for, I believe it was around 16 months, so more than the 12-month period, the upper tribunal did not believe that section 45, it would be in this instance section 44, sorry, it would be in this instance section 45, it envisioned that anything more than the maximum of 12 months could indeed be awarded. What I'll do now is just touch very briefly on determining how much of the universal credit has in fact been paid towards the rent. So obviously you won't have access to the universal credit data. And so what you'll need to do is to contact and work with the affected tenants. Ask them to obtain the information for you and request that information from the other various departments if they should need to do that. Once you have that information, there is a set formula that must be used when calculating how much rent should be repaid to either the tenant or yourselves. I won't go into that formula now because it's not the simplest formula to consider, and it's, I don't think, going to be of any benefit to go through that in any significant detail now. But of course, if you do require any assistance, myself or any one of the other barristers in the housing team and 42 will be able to assist. So then looking at costs, it's right that within the tribunal system, you can apply for your application and your hearing fee to be reimbursed. Those are the standard fixed costs. And it's right that you won't be able to get any other costs unless you're able to prove that there was unreasonable conduct under Rule 13. One last thing to remember is just in relation to enforcement, county court bailiffs can enforce the order and recover the debt if the landlord does not make payments. So that's it from me for the moment. What we want to do is just use the rest of the time to answer any questions that you may have. If we can ask you to put those questions in the question and answering function, therefore myself and Howard can view those and we can answer them for you. If there are any questions there that we think actually we need to get back to you on, we'll try our best to take your details and liaise with you outside of this webinar to go through those details. And of course, feel free to email both myself and Howard with any other questions that you may have outside of today.
Right. Hello. Good afternoon. Hello, Natalie.
Hello, everybody. Hi.
Hello.
So if we kick off, really, that there have already been some questions in the question and answer function. So it just says Q&A at the bottom of the screen. If you've got any questions, put them there. We can just, I know Howard's already answered some of them, but if we can sort of just go through the ones that have already been answered, just so that everybody else has the benefit of hearing those questions and the answers. So there is a question here which says, will a private landlord be subject to a rent repayment order if convicted under the Protection from Eviction Act, say for lawful eviction, and if yes, on what grounds? So this was one of the points that Howard went through in his slides, and the particular section is section 1 of the Protection from Eviction Act. Howard, I don't know if there was anything else you wanted to add in relation to that question.
Just very briefly, often that's one of the more difficult offences to rely upon for a rent repayment order, unless there's been a conviction. It's much easier to rely upon the strict liability offences, as I mentioned, where there's very often less of a dispute as to facts. So that's something to bear in mind. But if you've got a conviction or you've got very good evidence of an offence under the Protection from Eviction Act, then that's something you could rely upon. Over to you, Natalie. Natalie, did you hear that? Did you hear that?
Well, my Wi-Fi dropped out then, so, right. So I may have disappeared for a little while. But I heard most of what you'd said in any event. I just sort
Excellent.
Of, went silent for a bit.
Okay.
So there is there's just in terms of the slides and the recording, they will be online on the 42 Bedford Row website. You'll be able to access the slides and the recording, and also on our YouTube site. They're all clicked. You can easily get to it from the website if you missed any of it, or just need your memory refreshed in relation to any of the particular points that we've gone through. was there anything in particular that you wanted to deal with in terms of the questions, Howard, or should I pick another one?
Just, I think one that was asked about limitations on the jurisdiction in relation to rent repayment orders. So the principal limitation on jurisdiction, once the offence has been proved or there's been a conviction, the principal limitation on jurisdiction is that the amount awarded must relate to universal credit paid over a 12-month period. So that's the principal limitation on jurisdiction to bear in mind. And I think local authorities really need to weigh up the advantages of rent repayment orders as against applying for a civil penalty, where larger sums may become an issue. I hope that's helpful. And I hope Natalie's still with us. Natalie, I think, has got another question that she may be able to ask. I don't know if there are any other questions. I know Natalie had a question about what do we do if the landlord is a limited company or has folded and no assets, and so that's something that happens from time to time. And one of the suggestions that Natalie had made in relation to that, and this is Natalie's answer, is that you could consider applying for a rent repayment order against either the superior landlord or the mean landlord, that's to say the intermediate landlord, if one of the companies has gone into liquidation or is no longer available. If that is the case, again, it's probably better to think in terms of a civil penalty order, because a civil penalty order can be made against individuals and not simply the landlord. So I think local authorities have got to look strategically at these kind of applications and consider them alongside civil penalty orders as well as rent repayment orders. Natalie, I'm afraid I took one of your questions there.
No, that's completely fine, Howard. There was another question just about clarity in relation to the 12-month period, because there was lots of reference to that in the talk that we both gave. And so the question is really, when does the 12-month period run? And so just to be clear about it, a rent repayment order can only cover a period during which the offence has been committed, up to a maximum of 12 months. So the best way to think about it is, for example, if there is a property licensing offence and that offence has only lasted, say, 8 months, you can only get rent paid during that 8-month period rather than the 12 months, because it's only for the period of time that the offence was committed. And then the award must relate to the period during which the offence was committed, so not exceeding the 12 months. The other thing is just to note that there is an exception in relation to when that 12-month period runs. And if you're looking at unlawful eviction or violent entry offences, the 12 months in relation to the rent being paid is the 12 months preceding the offence that counts, and you end on the date that the offence was committed. And then the last reference, which I've already made essentially in relation to the 12 months, is the application. I think Howard really said this really is the application has to be made within 12 months of that relevant offence. So there's lots of discussion about 12 months, but that hopefully breaks down what each of the 12 months relate to. Howard, did you want to add anything in relation to that?
No, I think you've summarised it very well. I think there's one other thing to bear in mind where there's a licensing offence, either a conviction for a licensing offence or it's proved before the tribunal. So it is possible for a local authority to prove an offence was committed during the 12-month period before the application was made, and then to say, well, we want the rent repayment order to relate to an earlier period when the offence was committed, if, for example, larger amounts were paid in respect of universal credit for that period. So you might take an earlier period of 12 months when the offence was being committed for the assessment of the quantum, as it were. So that's again something to think about. You're not restricted in terms of which 12 months. Good. Well, I hope that's been helpful to everyone that's here. As we said earlier on, if you think of any questions once you've read the PowerPoint, then please don't hesitate to get in touch. We're very keen to assist local authorities. We have experience of rent repayment orders, and what we've given you here is just a very broad outline. Each case must be looked at quite carefully on the facts, and this is a developing area. There are upper tribunal cases being issued now nearly each month, so it's well worth thinking carefully before you do anything else, before you start down this route. Natalie, would you like to say anything else?
I think you've rounded it off quite nicely, Howard. We want to provide a webinar which deals with the relevant points for you to consider, but of course contact us or anyone else within the housing team if you've got any other specific issues. So I think we'll leave it there for today, Howard. Thank you all very much for attending and listening and asking the questions. Thank you.
Thank you very much. Goodbye.
Goodbye, everyone. Thank you.